Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, everyone. Welcome to another edition of the Empowering Plans Podcast. I'm your host for today, Brady, and joining me is one of our consulting attorneys, Nick Bonds. Say hello, Nick.
Hello, Nick.
You know, when I first started at FIA, Nick, almost 5 years ago, that, say hello, Ron, that was a thing. And I didn't think it would catch on to me, but it really is a great way to break the ice and start the conversation. I don't know what you think about that, but it's sort of grown on me.
I see no reason not to keep that joke rolling.
If nothing else, when Ron goes back and listens to these, which I know he will, he'll get a good chuckle out of it. So I think that alone is probably worth it. So it's really part of the process, just like Pat the Man Santos is our wonderful producer. But today we have something in store for our listeners, which I think is very exciting. No sarcasm there. We're going to talk about some emerging trends in ERISA litigation. I think it's a good break to talk about something different than COVID, get off the topic of depression and, isolation and pandemics and talk about some exciting litigation stories, things that we're seeing in the industry, some trends, because look, ultimately it's to everyone's benefit to look down the road and anticipate a problem and take some steps now, right, proactively to prevent that from becoming a problem for plans. And we've seen a couple of interesting cases and some stories, some articles from some pretty well-regarded legal sources about a potential new issue that plan sponsors could face with respect to plan assets. And so, Nick, I know you've been digging into this at length because it touches on a lot of interesting areas like intellectual property and data privacy. So why don't you sort of give us an overview of what's been going on, what should plans know about, and how can they guard against this?
Yeah, I think it's never a bad thing to remember that there are things besides COVID in the world to be worried about. So we're keeping our eyes open. And one of the new areas that we've been seeing a little bit of development on is the issue of plan data and data privacy, and specifically the application of ERISA fiduciary duties to plan data as a type of plan asset. I know a lot of people, when they consider how they need to protect and secure their protected information and their plan data, their participant data, their instinct is to think HIPAA, and I have to make sure I'm complying with all the HIPAA privacy requirements. But there's been sort of a growing trend in ERISA litigation where plaintiffs are making the argument that plan data, and specifically participant data like PHI or just general participant information, should be considered an asset of the plan, which means the fiduciary duties of the plan sponsor and the plan administrators would attach and require them to take steps to protect that data. And that also means that a potential breach of that data or an improper use or sale of that data can give rise to claims of breach of ERISA fiduciary duties, in addition to any potential HIPAA concerns or other privacy law concerns that plans have to watch out for. So that's sort of the broad strokes of this issue that we've seen kind of percolating through the legal system.
Yeah, and Nick, it's interesting. When you think about plan assets, at least when I do, I immediately want to look to a statute or look in ERISA and see what the definition is. But of course, as we know, it doesn't actually define plan assets in a meaningful way. It sort of defers, right, to the Secretary of Labor or the DOL to determine what plan assets mean. I mean, looking at some of the cases before we recorded this, I found that, a lot of judges don't seem to want to assign a very narrow or very comprehensive definition. They keep things very broad. And plan assets, I found one case that sort of described it as anything of value. And, as we know, especially in the last couple of decades, personal identifiable information or, personal data is becoming more and more seen as a valuable asset, as a valuable commodity of a person's sort of entire being. So, and if you think about the amount of data collected, we know this in other industries. Think of, what your smartphone collects on you, geolocation data or, bank transactions or social media posts. There's so much data already out there. But really in the healthcare space, I was surprised to learn when I went back and looked to see the kind of data. I just remind myself, frankly, of what's actually collected in terms of claims data. Obviously, your PHI includes your, who you are, your name, your marital status. Sometimes it includes your income, obviously any health information you have, any conditions, medications you're taking. And so it's kind of scary when you think about it that way, right? The kind of profile that could be built about you based on your claims data. It's really sort of a new frontier in thinking about how this information would be considered a valuable asset.
Oh, absolutely. Yeah, it is almost terrifying when you sit back to think of the amount of data that can be extrapolated just through like browser history or through your phone. But when you have a data set that includes like your health claims, includes your medical history potentially, includes things like how much you're paying for healthcare, how much you're contributing to your employer sponsored plan, that kind of thing can allow a lot of these apps or a lot of these companies that use that data, they can extrapolate so much information from such a comprehensive data set. There's no question that the kind of claims data and individual information that a plan would have on hand would be extraordinarily valuable. I think that that really does sort of put a bow on the argument that plan data can, at least in some circumstances, be considered an item of value and potentially a plan asset under that broad ERISA definition. That you made a good point there, that courts are fairly reluctant to try to whittle down that definition or put it in too small of a box.
Right. And when you think about, the kind of protections that are in play here, we're talking about fiduciary duties, which if anyone listens to our podcast or is generally aware of FIA, you know how we feel about fiduciary duties. I think the saying we use is if it walks like a duck, it talks like a duck. We apply that in the realm of fiduciary duties and whether you have them. So many entities that claim not to be fiduciaries are nonetheless found to be fiduciaries based on their actions. And if you are a fiduciary, you can be a plan sponsor, a plan administrator, a trustee, some kind of a plan investment advisor, a broker can even be found, depending on how it's acting, right, to be exercising sufficient control over plan assets such that those fiduciary duties are triggered. And one of those duties is a duty of loyalty, and another is a duty of prudence. And I'm looking at the cases here, and those two seem to be the ones that these attorneys are seizing on, right, to make these cases, that you have breached the duty of prudence and loyalty that you owe to your plan members by misusing their plan assets, by basically violating their privacy. And that seems to be the basis, right, the hook that gets these cases into court. And we've seen more and more of them more recently. And I guess, maybe we can talk about some of these cases, Nick. I mean, I know for the most part, they're about pension plans that, as we know, same body of law governs, whether you're talking about health plans, welfare plans, pension plans. They're the same body of law, being ERISA, is at play here. So, I mean, is there a particular case maybe that has something we can learn from, or what happened in a couple of the cases that you were following that gives us reason to pay more attention to this issue?
Yeah, we've seen, like you said, it's been mostly litigated in the realm of retirement plans governed by ERISA, but the same sort of logic would apply to a employee-sponsored health plan governed by ERISA. And the main issue is that the sponsors of these plans have been using the data that they accumulate through the plan on their participants in sort of unsavory ways under ERISA, and they've been alleged to be breaching those duties of trust and those duties of using plan assets to the exclusive benefit of their participants. One of the examples, most of these cases haven't been fully litigated. We've seen them sort of settle, but from what we've gleaned from the settlement agreements, we've been able to tell that essentially, I think it was Vanderbilt University was actually being sued by the members of its retirement plan, saying that the university was taking the data of the plan participants and allowing that data to be used to market other retirement plan packages or other benefits to those participants. So essentially, they were capitalizing on the data that they collected through their plan to try to enrich themselves or their brokers through turning that data into a chance to sell more products to their beneficiaries. So that was sort of frowned upon by the court. And I think that that's a big part of the reason that that case actually wound up settling, was because they didn't want to have to face all the potential liabilities of a breach of ERISA fiduciary duty. And we've seen in a lot of cases that allegation of a breach of an ERISA fiduciary duty can be a big club in a plaintiff's bag against a group. Another one of the cases we've kind of looked into was a situation where Northwestern University's retirement plan was being essentially mined for cross-sell opportunities, chances to, again, profit off of the beneficiaries of the plan, which is a pretty egregious violation of the spirit of ERISA fiduciary duties. I don't know, what do you think about those cases, Brady?
Yeah, I mean, so as you're sort of describing the fact patterns, I'm thinking, certain buzzwords are appearing in my head, like prohibited transactions, things like that under ERISA, which are outlawed, right? And if you think about the kind of world we live in today, obviously there is tremendous pressure on health plans to keep costs low and to implement cost containment programs. And there are, equally a ton of vendors out there who are soliciting their products and advertising to plans claiming to have, the solutions to the cost containment question. And, some of them are very good, by the way. However, I think the risk that this presents when you look at what happened in these retirement plans is the temptation for health plans to just sort of give claims data to various vendors that then will use that data. And then you're advertising a certain service to plan members. That's where you've got to be careful. I mean, obviously, the counter to this argument, and it's the reason why many cost containment vendors are allowed to operate in this space, is if the plan can actually show, right, savings, real savings in its health plan, or they need this vendor to perform essential healthcare operations, right, then it's okay. And it's exactly why you see under HIPAA, there's exceptions to the HIPAA rules that allow for disclosures in certain cases. I think the trouble, though, as we just said, comes when you're trying to market sort of other products to an employee base. So things that aren't really related to the health plan, they're more commercial in nature. I could see how that would be where plan sponsors could get in some trouble, or other people who nonetheless, are still fiduciaries. They may not see themselves as fiduciaries, but they may have access to this claims data. And they're thinking, wow, I can really sell this data to Apple, right? And I just market a bunch of new iPhones to my staff. I mean, that's sort of an extreme example, but that's at least what I'm thinking about here when you were describing those cases. Because essentially, to your point, Nick, these universities were using the claims data. In this case, I think it had to do more about investments in certain stocks. And they were using this data to market other financial instruments that looked like to people on the pension plan. And that was what was considered a prohibited transaction and a misuse of the health plan, or rather the retirement plan data. So I think it's very transferable to our industry. And like I said, looking at how full the space is with, vendors competing for attention and for sales, I think there's a real risk there going forward. But I mean, considering there's a risk, Nick, what are we advising our clients to do that they may not already be doing, or, where should they supplement their privacy protection to make sure they don't find themselves in a situation where they, are the first case that drops the hammer,
Yeah, I think that it's probably only a matter of time. We've all seen sort of a rise in these situations where companies are having pretty egregious breaches of their data, and with the potential argument that that data itself is a plan asset and that plans have a responsibility to protect that data from being utilized in an improper way, it's entirely possible that some of these health plans could experience a data breach and not only experience issues under HIPAA, but also get hit with a potential breach of ERISA fiduciary duties for failing to protect that data. So I think one of the things we would recommend plans take a look at, the good news is a lot of the steps that plans take currently to protect their data under HIPAA will probably help guide them to protecting their data in this way under ERISA claims. But it's important that they sort of review all of their data security, their cybersecurity, and it's worth taking a look at their ASAs and all the language they may have in their BAAs with business associates, just to make sure they know who could be operating potentially as a plan fiduciary, anyone who may have access to this data, and making sure that they are taking the proper steps to ensure that that data isn't going to be used in a way that could give rise to these ERISA claims. They may want to, given how many people are working from home these days, probably on a company laptop, it's good to look at how that data is being transferred over that laptop, be it through a VPN or some kind of secured network. Also, we've seen plenty of potential HIPAA violations through Zoom. That's something we've talked about in the past. And if you are potentially disclosing any sort of sensitive data over Zoom, we've all seen how insecure Zoom can be. It's gotten a little better here recently. I think that Zoom's made some modifications to their platform, but all the means that we use to keep doing business and continue communicating virtually and from home could potentially leave plans vulnerable to these sorts of data breaches. And so we would just advise them look over all of their current security, all of their protocols that they have in place to protect their data, but with the lens of potential ERISA claims down the road, and making sure that they know who is the plan fiduciary and that those fiduciaries are following the rules of ERISA where it comes to this sort of plan data and participant data, just to make sure that they don't have any additional headaches down the road. And in the meantime, we'll definitely be keeping an eye out for more of these type of arguments to see what arguments are being made that this sort of data is or is not a plan asset. But this is definitely an area that we'd expect to see plenty of developments down the road. Do you have any other ideas you would recommend, Brady?
Well, I think you covered most of it there. I just would add that where we do see a lot of our clients sort of, get into trouble with this issue is sometimes in their contracting with vendors. So, contracting to be updated periodically, they need to be reviewed. To your point, Nick, the lens that most employers and plans are looking through is HIPAA when they're considering data privacy. But I think the point we've made on this podcast is that the ERISA lens is a lot more broad, right? There's more ambiguous definitions involved. There's definitely some kind of concerted effort among plaintiff attorneys to try and get these cases into the courts. So if you do have questions about contracts and what they say, what you need to update, send them our way, pgcreferral@fiagroup.com, as well as any other consulting questions you may have on this topic. But to Nick's point, we'll be adding this to our repertoire of, subjects that we're following, trends that we're looking to as the year unfolds and beyond. And it'll give us something, frankly, other to talk about than COVID, which is a bit of a refresher, even though, to your point, Nick, it's something else to be wary of. But we'll be on top of it. We'll be on the lookout to see, what developments happen in this area, if any. But for now, I want to thank you, Nick Bonds, Pat, the man producer, and on behalf of myself and the FIA Group, thanks to everyone for listening in to another edition of the Empowering Plans podcast, and we'll talk to you soon. Take care.